Muito obrigada pelo convite para vir aqui hoje. Aí, meu marido, estamos sobrevientando sua cidade linda. É uma honra apresentar minha pesquisa a esse grupo de eruditos tão estimado. Did it work? Did you understand? I'm sorry that is the extent of my Portuguese. First, I want to congratulate you on this great project. You're talking about how new it is, and yet you've already accomplished in some ways much more than the law and society movement in the United States. I think that you have people from the government here, well, we're in the government building here, saying, please tell us. And that's a bridge that we have not crossed as well in the United States, which is something I'll talk about in one of the seminars. But the broad theoretical question I'm addressing in my talk today is reflected in the title of the talk and a book that I'm finishing with Beth Nielsen and Ellen Berry, and it's called Rights on Trial. The simple question of the research that we're asking is whether and under what conditions law in the form of rights can successfully intervene to remedy various kinds of inequality. To examine the question, we look at the case study of U.S. employment civil rights, which, like more and more economically advanced democracies, seeks to remedy past racial inequality and discrimination by asking people who have been discriminated against to file lawsuits to remedy that discrimination. Of course, there are other ways of accomplishing racial integration in society. Norway, for example, has quotas and affirmative action policies, not just in education, but also in executive boards of large companies, public companies. Germany's also considering the same. Canada has things like that as well. But we're looking particularly at the model where people who have been discriminated against as a member of a traditionally disadvantaged group seek remedy through law. So this is a large-scale project about discrimination in the workplace, and we're looking at litigation as a social change model from a variety of perspectives. In so doing, I'm beginning to outline the contours of the paper that I'm presenting, and we'll go into this more in the seminars. I hope you'll come, which is, I've been calling it law in motion, or an immersive view of law and society, talking about different methodological approaches. Although the history of race relations and of enslaved Africans and indigenous people are quite different in the U.S. and Brazil, we do face some of the same challenges of a large federal district, as well as the willingness and the hope of society to create more equality across groups in a very large, very diverse federal system. So our project is based on thousands of observed cases, and I'm going to talk a little bit about the broad project in these thousands of cases, but I'm also going to primarily focus on two of the cases with an explanation of how they deviate from and typify the norms. So sort of two case studies, and I'll tell you how they're alike and different. We developed a multi-perspectival design, which is also multi-methodological, and includes input on these issues from parties on both sides. So we've interviewed plaintiffs in employment civil rights cases, defendants in employment civil rights cases, plaintiffs' lawyers, and defense lawyers, often in the same case. So we literally have all four of the perspectives on the case. Now, both the cases I'll talk about today went to trial, so we have an authoritative resolution on whether or not discrimination occurred. One was a trial by jury, and one was trial by a judge. So today what I'll do in my research presentation is set out the socio-legal theoretical framework for the analysis, talk about the systems of U.S. courts, and go through some of our published findings, which mostly have been quantitative with some qualitative a little bit. Then I'll locate the two cases in the sample, present the qualitative data, and conclude by discussing implications. Of course, we recognize that all litigation entails a conflict, right? And the resolution of any particular conflict not only determines the resolution of that dispute, but also sets the rules for disputes and cases that follow. In employment civil rights cases, these contests take on special significance precisely because anti-discrimination law is what Berkey and others call a litigious policy. That is, we use courts, the law, to enforce employment civil rights. So our shared social goal of creating racial equality in the workplace, or at least racial non-discrimination, depends on individuals bringing lawsuits against business. These contests are morally consequential. Plaintiffs feel they've been discriminated against, which is very visceral. Their rights have been violated, and their identity as a worker has been insulted. Employers are defending against the charge that they engage in discrimination, which is very fraught. People don't want to be accused of discrimination. So theorists of legal mobilization and legal consciousness have written extensively on how effective this kind of model for social change is, using courts for social change. And I've roughly divided these scholars into two camps, optimists and pessimists. So there are the optimists who believe that litigious policies work by some measure, and pessimists who say the courts are a hollow hope, to invoke Rosenberg, who's sort of the classic statement in The Hollow Hope. But the optimists that I'm working with and speaking to are Catherine Albiston, who has work on the Family and Medical Leave Act concerning good workers and the family wage. She suggests that law is very useful for workers who are trying to get family leave. Engel and Munger, and two other law and society scholars, who suggest that disability rights primarily have an effect by shaping the consciousness of individuals rather than through the courts, but that's still very effective on advancing the social change. And then Michael McCann's book, Rights at Work, where he finds that a rights discourse, and at least the threat of the lawsuit that can go along with that, served as a catalyst for a number of pay equity union campaigns in the 80s. Although ambivalent about litigation, those scholars are optimistic about the role of law. Other scholars are more skeptical. In the Civil Rights Society, Kristen Buemiller spoke of the limitations of an anti-discrimination law model, suggesting that it's unrealistic for individuals to take on the mantle of having been discriminated against. They don't like the label of victim. They fear recourse to law will create more problems than it will solve. Sam Lucas, in his recent book, is skeptical of the entire discrimination frame and advocates us beginning to think in the U.S. about race relations in a new and different way. And he argues that focusing on individual cases of alleged discrimination really obfuscates the more fundamental inequalities of race and gender that these social interventions are trying to address. So in addition to those theoretical debates, contests over the construction of discrimination claims are central to policy debates about whether employment civil rights and the broader cultural debates of the use of law to redress inequality. Employers say that discrimination lawsuits and the accompanying infrastructure are primarily frivolous and that access to the courts should be limited. Conservative commentators suggest that lawsuits are another example of how litigation has run amok in American society, creating an excuse factory for bad workers and burdening business with unnecessary costs. So we sought to examine the questions by looking at people who had mobilized their rights, who thought they were discriminated against in the workplace, and had the legal consciousness to go to a lawyer or to bring a lawsuit. We've done so through a combination of quantitative data on a large random sample of federal case filings from 1988 to 2003, and by in-depth interviews with parties and their lawyers. So just to foreshadow the argument, we find that both from a quantitative and qualitative perspective, we see plaintiffs and plaintiffs' lawyers on the one hand and defendants' lawyers on the other hand, having sharply divergent views on the validity of discrimination claims. Defendants react as though all claims are sort of bogus or at least legally insubstantial. And the litigation process doesn't bridge this gap. There's no agreement on when discrimination has occurred, and so it's sort of furthering the divide in society, we're arguing. So first, some background about employment civil rights. Click. The Civil Rights Act was legislation passed in 1964, Title VII of which prohibits employment discrimination in the workplace based on race, sex, religion, and national origin. So if you're in your workplace and you experience what you think is employment discrimination, first you file with a regulatory agency, which is the Equal Employment Opportunity Commission, which primarily just pushes cases along until their time runs out, and then you go to court. Although, if the EEOC represents you in your case, there's a high degree of success, but it's very rare. If the case is not resolved at the EEOC, the target of the discrimination lawsuit has the opportunity to file in court. So here are the data we're using, and I should thank our funders, the National Science Foundation, the Searle Foundation, the American Bar Foundation, because this amount of data collection is no easy task, and the difficulty of this kind of empirical legal research we'll talk about in the seminars. But our book is based on 1.6 million Equal Employment Opportunity Commission filings, which interestingly are incredibly hard to get out of the government. About 6 research projects have access to these data. They will not give them to us. And so I was really struck in the first panel of everyone saying, please come get our data here. These are really impossible to get in the US. So I'm not going to talk too much about it today, but then we drew a random sample from the 7 cities that are represented here and sent teams of coders to the record centers to code the case files. And that's the only way to get basic data on what's happening in federal courts. If you look at appealed opinions, it's a very narrow slice. Click. So employment civil rights are the green line over time. No, green is all federal cases in the US, and the dark blue is employment discrimination. So you can see that we've had a massive run-up of the proportion of federal cases that are employment discrimination, and we have about somewhere between 15 and 20,000 of these cases entering the federal courts every year. This is, in most years, employment civil rights is the most common claim in federal court. So there are big implications for the cost to the court system, in addition to how ordinary people feel that the state has represented their claim. So will you click? And click again. So these are the types of claims that are filed in the United States. So the most kind of common claims of discrimination, and you can see that overall race remains the most frequently claimed kind of discrimination, and then sex, age, disability, national origin, and then religion, family, sexual orientation. Of course, we don't have federal protections, so there actually should be 0, but there's 1%, so some innovative lawyers are probably trying to make something of it. But those are the largest categories. Click. These are the same data over time, so you can see how we're converging towards sort of an equilibrium of all the types of the 4 most common types of discrimination coming together. But race remains always the biggest focus of our discrimination regime. Sex discrimination touched race in, I guess that looks like 1992, but really this is primarily about race. So 25 to 30 years after the Civil Rights Act passed, race discrimination continues to be the biggest problem represented in the court system. Okay, click. Yeah, second striking phenomenon is the predominance of individualized claims. So one of the things that people talk quite a bit about are class action lawsuits, and I did some expert witness work in the Walmart class action lawsuit, which is the largest employment class action ever sought in U.S. court. It failed. Or it failed if you're on, the workers failed to bring the case. But class action cases are a very small percentage of the caseload. The vast bulk of this kind of litigation is one person who thinks they've been discriminated against, bringing a claim against a large corporation or city or a municipality. Class actions are less than 1% of the filing, but probably 90% of academic research about employment civil rights focuses on class actions, but that's not what's coming to the courthouse. But of course, what we want to know is, how do these cases end, and how does that affect workplace inequality? Click. So we analyze outcomes as a sequence of possibilities, right? So the left bar represents all cases filed, and some 19% of cases are dismissed, right? So the person didn't file the paperwork right, they didn't have the right to sue letter from the EEOC. Of the next category, 50% settle early, right? So there's a financial settlement, usually kept confidential, so researchers don't know how much companies are paying. And they agree to hold the company not liable on that issue. We did interview, we found out that the average settlement is about $30,000, 60,000 reals. See, I'm good at math. So if a case doesn't settle early, it has about a 50% chance that it will end on motion for summary judgment, which is a moment in the case when the judge has the ability and a lot of discretion, actually, to kick a case out as not having a triable issue of fact. If it doesn't settle early, you have 50% chance of loss on summary judgment, and then about half of the remaining cases, or 8% overall, settle late. And we divide settling early and settling late into two categories because early settlements tend to be very small, really, in the thousands of dollars more than the tens of thousands of dollars. But once the sort of mini trial around motion for summary judgment has occurred, the costs are much more, and the settlements, therefore, are much more. 6% of cases that walk into the courthouse door in the United States go to trial. And in those, plaintiffs win about 1/3 of the time. So this is a story that you hear quite a bit from researchers on civil rights. Well, look, plaintiffs are winning about 1/3 of the time. That represents 2% of cases that entered the federal court system and like 0.005% of all that entered the Equal Employment Opportunity Commission. Click. So to set the stage for the qualitative data, here are some findings from work we've published. In individualized justice, we model the sequential outcomes that I just went through there, right? I showed you those sort of bivariate, but we do some more sophisticated quantitative analysis, and we find that the most powerful predictors of outcome are whether plaintiffs have a lawyer, right? So lawyers, very important. And 20% of these cases are pro se, meaning the person entering the case has no lawyer. They're representing themselves in this massive federal judicial bureaucracy. Whether the litigation involves any kind of collective action also has a big impact, right? So collective action like the EEOC is representing you, or a public interest law firm is representing you, those also have big predictive effects on outcome. But interestingly, the EEOC priority codes, which they grade the cases, A, B, C, if you're getting an A, if it's a really good case, they have no effect on the outcome in court. The type of claim you're filing, race, sex, age, disability, pregnancy, equal pay, that has no effect on outcomes. So it's pretty interesting. It's about lawyers and lawyers who professionally lawyer for social change. Then there's our situated justice piece, and there we show how the assessment of law's fairness is situated differently for litigants, defendants, and lawyers based on social, organizational, and institutional contexts. That one's recently out in Law and Society Review. And then in examining empathy is a paper where we're looking at the judge's decision to grant motion for summary judgment or not, and the judge's personal characteristics. So are judges who come from traditionally disadvantaged groups more likely to allow discrimination cases to go forward? The answer is yes. White judges are less likely to allow cases to go forward, and white judges actually white male judges actually have a they actually allow civil rights to go forward more frequently when the plaintiff is a white male. This is just the statistical work that shows that judicial characteristics have an impact on the outcome. So judicial characteristic, minority, highly significant, female, not significant, and the party of the appointing president of these federal judges has no effect. And that's a big story in employment civil rights, is right there, Democrats and Republicans, and they're all going to vote they're all going to decide things the same way. And finally, in race and representation, our data demonstrate that various plaintiff and defendant characteristics are associated with the ability to retain counsel. And this is a big problem. for the employment civil rights model in the United States, that holding everything constant that we possibly can, it's much harder for African American plaintiffs to retain counsel. So the upshot of our quantitative analysis thus far is that it's difficult at the outset to assess the prospects of a case, right? How likely is it that this person was discriminated against? How likely is it that the company will have to pay out? Most parties choose not to invest in litigation and they settle for a relatively modest sum, but there's a lot more going on in these cases than how the lawsuits define them. So being the multi-method scholars we are, we turn to the qualitative data in the research. Click. So here's how we chose the case filings were randomly drawn, and to build the methodological accuracy of the project, we drew this table. So race, sex, age, and disability are the four most frequently cited claims of discrimination, and then those ends of cases that I told you about before: dismissed, early settlement, late settlement, and go to trial. So within each cell, we picked two cities, which were two cities where the researchers happened to be living, because this kind of research is expensive. So it was Chicago and San Francisco. In those two cities, we randomly drew within these systematically designed cells. So there is a sort of methodological defense to the cases that we studied. Every case had an equal chance of being chosen. So we came close to our ideal, interviewing parties in multiple cases, in about 41 multiple cases. So we interviewed over 122 people, I think, at last count. We achieved roughly a 50% response rate, and we went back and offered to pay initial refusers, because we started presenting the research and heard from people, well, maybe the people who aren't willing to talk to you either had a particularly great experience with the law or a particularly horrible experience with the law. So we got another grant, and people would do the interview for $100. Okay. So in the two cases I'm going to present today, we had interviews with multiple parties and their lawyers. So these are really multi-perspectival. And the cases are paradigmatic in some ways. They're brought by individuals. They primarily have disparate treatment claims, which is they're alleging they were treated differently versus like there's a systematic pay practice that disfavors women or people of color. But they're also unusual because they go all the way to trial, which, as I've told you, is only 2%. Both were filed and concluded in the 90s, and these are just fascinating cases, but it turns out every case is a fascinating case once you start doing the interviews. Or maybe that's just me, but everyone here, because we're all empirical legal researchers. But one of the most interesting things is that when you go back, plaintiffs recall everything with great emotional detail. And plaintiffs' lawyers remember a little bit more. Defendants and their representatives far less likely to remember the details of the case. But eventually they get there. So the first litigation account I'm going to tell you about is that of Annie Daly, an African-American woman working as a supervisor of supervisors in a large telecommunication firm. A new director took over as her boss, and it was a white woman. Annie began to experience what she regarded as racial animus. And you can click and I'll show you what Annie said. So one thing I want to point out is when you're reading the articles, there's actually there's a website on the American Bar Foundation where you can listen to the people say these quotes. So we've taken them out of the interview recordings, and as you're reading along in the articles, you can hear the people. So at some points in the research, we're doing analysis of emotion. And so the recordings are very helpful because people cry and so on. But for here, we'll just read Annie Daly. Annie Daly said, I must have had 6 or 7 supervisors under my supervision, and probably I had 4 supervisors who happened to be qualified African-American supervisors. And it wasn't that I was specifically going out and looking for African-American supervisors. I hired people that were best qualified. And then I was accused by my director of hiring too many African Americans in my department. And like I said, once I got my team together, that's when we really began to start pulling things together and meeting our goals. So she went to the her director's supervisor to ask for support in disciplining non-performing white subordinates, and this director told her, you can click, Annie said to me, so I'm telling the director, hey, this person's not doing this and this person's not doing that, but she, meaning her director, does not support me in correcting them, right? So there was one particular supervisor who made it very clear she wasn't going to report to a black woman. She even called me a black bee. And I start to say, to your face? But she says, and I'm telling her this stuff, and she's not supporting me. My director is not supporting me at all. So when the director didn't support her after she was called a black bitch, she went to Human Resources, which is where all employees are told to go if they experience discrimination. She talked to HR about the problem with her supervisor, and Ms. Daly was terminated from her position without warning 2 weeks later. After her termination, Ms. Daly approached a young attorney who had represented other plaintiffs in the telecommunications company, and in the next slide, he explains why he took the case, even though there was no smoking gun evidence of discrimination. So you can, and here he is. He says, I have a strong recollection of her, and she's somebody who I very quickly got a sense of being a quality person, who I'm sure is good at her job, and somebody who seemed to me like a quality employee. She gave me an explanation of how things happened, and based on my recollection now, involved the subtle kind of racial discrimination that you see a lot in the workplace. There were no epithets. So he took the case despite the fact that, from his perspective, there was no racial epithet, even though there was this very misogynistic gendered term. So this demonstrates the interesting way that plaintiffs' lawyers think about what constitutes a strong case. Ms. Daly was one of the lucky ones. She retained a lawyer who believed in her and believed in her case. With his help, she filed with the EEOC and later in federal court. She named both the telecommunications company and 2 individuals as defendants. The telecommunications company retained outside counsel who had a very negative view of the case, and Ms. Daly's lawyer. The defense counsel characterized Ms. Daly's lawyer as a bottom feeder. Does that translate? Like a scummy lawyer. Okay. And said that he was reaching to get a large award, and reported that he tried several clearly unprofessional tactics at trial. Our interview with outside counsel did tend to confirm Ms. Daly's analysis of how she was perceived and portrayed. Okay, and so this is the defense lawyer, and she told us, I'm pretty sure that Annie Daly, supervisors, and all the people in that line, because there were some individual defendants in that case too, felt pretty strongly that everything they had done was absolutely kosher. And Annie did not have a case. She had not been discriminated against. And my recollection is that the in-house lawyers supported that, both the lawyer's name and his boss. Mm-hmm. I took Annie's deposition, and I didn't think Annie was a very persuasive person in the deposition. She came across as not terribly sharp and really kind of cold, not someone you would warm up to and feel sympathy for. She came across as rigid and sort of bitchy. So this is one of those rare qualitative research moments when you realize, oh, I'm getting really reliable data. She said she was perceived as a bitch, and the lawyer calls her a bitch. So that was nice and yet horrible for her. Okay. The case went on. The defendant organization filed a motion for summary judgment, which was denied. And on the eve of jury selection, the defendant organization offered Ms. Daly $100,000, which the judge and Ms. Daly's attorney recommended she take. But her attorney made clear that it was her decision. Ms. Daly declined, and the case proceeded to trial. The jury was largely white, included several older white males. Now, before I tell you how this case ends, I want to tell you that each interviewee that we had told something. We always ask, what's the most interesting thing or most important thing that you remember from this case? They all recalled something different. Miss Daly's lawyer recalled learning that the general counsel of the telecommunications company was intimidating witnesses in the hall of the courtroom. The case stopped, the jury went out, and the lawyer for the other side was questioned under oath about if he was doing witness tampering. So that's pretty rare. The defense lawyer recalled a particularly hostile African-American woman who was one of Ms. Daly's co-workers before she was terminated, and who she said exuded anger to the courtroom about being asked to be there. And the plaintiff, Ms. Daly, recalled that the night before closing arguments, a brick was thrown through her window. This caused her to go to the apartment of a friend in the middle after calling the police in the middle of the night, and she missed the last day of trial. When the case went to the jury, it did not take them long to return a verdict for the telecommunications company. In retrospect, of course, Annie wished that she had taken the $100,000 settlement offer, and she also worried that her case was hurt because she didn't show up for court. She didn't say that she knew someone from the company threw the brick, but she clearly thought that that was someone from the company. And yet, even as you're talking about this case where this woman lost, both she and her attorney say the most important thing wasn't the money, it was telling that company that they couldn't treat African American women employees like that. Okay, so here's what Ms. Daly said about the outcome. She said, I asked her, did you feel like you got what you wanted? Like, remembering back to the beginning of your case, do you feel like you got what you wanted? And she says, I was hoping to get some sort of justice. I was hoping to let them know that this was something they couldn't just continue to do to people, to let them know they're put on notice, to get justice, and then, of course, to get compensation. And so then I say, okay, right. And so as the process happened, where you go from thinking you're going to get justice to realizing that all you can get is money, how did you feel? Well, you can't really change people. You can't change behavior, but you can try to prevent people from mistreating people. You can't make them not be racist. And I thought this was one of the most profound things that any plaintiff said to us about the idea that law can intervene in racial inequality in a society. You can't make them not be racist, but you can make them pay. The second case I'm going to talk about is Franklin Williams. Mr. Williams was a laborer at a railroad for 15 years. According to Mr. Williams, his white supervisors became jealous of him. He was a laborer for a railroad for 15 years. So railroad is interesting because it's part private, but it's also part state run. So you have you have Title VII claims, but since it's the state, you also have constitutional claims for anti-discrimination. Mr. Williams innovated a safety technique for working on steam cleaning locomotives, which is very dangerous. There are a lot of toxic chemicals, and he was rewarded. In the company, they would offer a reward if you came up with a more efficient or more safe way of doing something. Mr. Williams believes that this was the beginning of the jealousy by his white supervisors that led to the intimidation based on race. So he scored highest on a promotion test and won that and was rewarded for the innovation, and yet he did not get promoted in the next round of promotions. This led him to file a charge with the Equal Employment Opportunity Commission, but he didn't pursue it. Sometime later, there was an accident. A large crane struck him in the head. He took some disability leave and returned to work. He had some suspicion that this large hook on a crane was intentionally deployed on his head, but he didn't have any proof. But when he came back to work after that injury, he was punished for 2 infractions and was terminated for the 3rd. Management suspended him for 5 days for missing work. So he came back from work after this injury, and there were 3 very quick disciplinary actions, and on the 3rd one he was fired. The first time he missed work because he was appearing in court for as a witness in some other trial. He said he gave advance notice, and you're legally required to let someone off work if they're subpoenaed to trial. The second infraction was for sleeping on the job. His supervisor said he found him sleeping in the break room. And the 3rd infraction was he was on top of a locomotive, and his supervisor said that Franklin said to the supervisor, "I have you in my sights," which the supervisor took to mean my gun sights, as in I'm going to kill you. Mr. William denied the validity of all of these disciplinary charges, and particularly the claim that he threatened his supervisor. He filed with the EEOC then in federal court. He tried to get a lawyer but couldn't. As we saw earlier, African Americans tend to have a harder time getting lawyers. But his wife was a paralegal, and so it's unique in some ways. We interviewed Franklin Williams and his wife in their home in the evening. They had all of their paperwork. It was fascinating. They had all their paperwork. This was, a decade later, and it was all out on the dining room table, and everything that they told us, they would pull out some trial record to show that it was true. They were convinced that he had been affected by racism and jealousy, and that not only in the workplace, but also in the legal system. And one indication of this bias that they told us about was the fact that the judge kept allowing the defense counsel to miss deadlines for trial preparation. And the Williamses asked the judge to impose sanctions, and this is what Franklin said about it. You can click. He said, "The judge wouldn't touch him with a 10-foot pole. We asked that he be sanctioned. We asked for judgment by default. Had I been late one time, they'd have kicked it out. You lose. But with him, no. They gave him all the time he needed." And so, going down, it was a tort that had never been filed against the railroad. That's that goes along with the constitutional claim. And he sort of changes subjects. In other words, my thing is this: I'm black, true enough, but don't fault me because I can read. In other words, the thing of it, now I see why you wanted the slaves killed. If I read, that means I can understand what you are trying to say and do to me. And me being, point blank, right to it, I don't want your ass to read. You can understand my system. You can know what's going on. And he takes a pause. I'll just tell you, Mr. Williams was drinking beer. So he's sort of changing subject. When you hear it, it makes a little more sense. He says, "To make a long story short, I took it as though they were telling me straight up, and let me be candid, nigger, I'm not going to destroy his career for you." Right? So his interpretation of what was happening in the judicial system was, I'm not going to harm this defense lawyer based on what you say. The case proceeded to a 3-day trial. It was a bench trial. Defense did not seek a motion for summary judgment, which is very rare. I think they just wanted to get it over with. On the last day of the trial, the judge interrupted the proceedings to announce from the bench that O.J. Simpson had been found not guilty of murder. So, are you guys familiar with O.J. Simpson? So he most likely, in an empirical sense, murdered his white wife. He was found not guilty. He's in jail now for something else, threatening someone with a gun. Anyway, big deal, interracial marriage violence, blonde white woman, it pushed every race button that we have in the United States. So everyone was watching it, and so the judge told people, because everyone was following it like this, the verdict came out. And then later that same day at the end of trial, the judge ruled against Mr. Williams. And Mr. Williams and his wife are convinced that it was the O.J. verdict that made the judge rule against them. Black people are getting away with things, so you're not going to win this case. And that is their understanding of how they exited the judicial system, and it is real and genuine. I mean, we laugh, and it's laughable, and yet it was real for them. They thought institutionalized racism had worked against them. And maybe it's not laughable. I mean, I don't know. We can talk about it. Mr. Williams and his wife felt that if the judge were to reread the transcript today, he would find for them. They really think it was in that moment. So you can click it. So he says, well, this is very sad. If it wasn't for my wife and children, I'd have done like this. And he goes, I lost everything, and I've never been arrested for anything. I'm thinking the law exists for everybody. You know how they say justice? It's just us. And Bush is proving that right now. I think I should get the book out since we're in the second term of the Obama administration. Okay. Inside counsel who tried the case for the defendant, Railroad, thought it was a clear case for the defense and did not even merit a substantial settlement offer. So you can click. So this is the lawyer for the Railroad. He says this individual didn't have much of a complaint. Nothing had happened to him. This guy lost his job, and I'll just also tell you, he never worked again. His wife continued to work, and he stayed home to take care of his children. He never worked again. This particular individual, nothing had happened to him. He was an individual with marginal skills. Remember, he had won that innovation award. Who was working in a job that he would not be normally able to command that type of salary, but because of the inflated salaries of the railroad industry, because it's coupled with government, he was in effect doing a lot better than he could. He was complaining about minor things with job assignments. You know, who got the shiniest shovel? So that just goes to show you the extreme gulf between how what happens in the workplace is experienced or considered by these folks. And you can click. This is the outside. This is another counsel for the railroad, Harold Ward, talking about the lawsuit itself. He says, when I terminate people and they jump up and tell me that they're going to sue me, I tell them the same thing. And right, this is sort of the message that Franklin Williams got. You want to sue me? Sue me. Lots of people have sued me. You won't be the first, and you won't be the last. But there's something you need to know. This is my job, and I get paid every day. Right, so you go to, this is a human resources attorney who's supposed to help the employee if they think they've been discriminated against. And he's been terminated, and the point that this lawyer is making is, I get paid every day. Do I want to win? I want to win everything I do. I'm a type A competitive person. But if I don't win, my world doesn't stop, and I still get paid. It's going to become your single focus in life. It's going to keep you from getting a job. Employers are going to see this seething pot. So Mr. and Mrs. Williams saw race in the events in the workplace and in the courts, which becomes an interesting reinscription of racial hierarchy rather than a remedy of racial hierarchy. The trial judge saw the case very differently from all of these parties. The transcript of the judge's ruling from the bench, he noted, that was another thing, he didn't consider it very long. He ruled from the bench at the end of trial. The transcript of his ruling from the bench, he said that it's very difficult to prove racial discrimination by so-called direct evidence because people don't usually announce their discriminatory attitudes when they make employment decisions. The judge also said the issue is not whether the employer is right or wrong. The law doesn't guarantee a fair decision. It only guarantees that there will be no decision made on the basis of race. I conclude that there's no evidence that Mr. Williams was treated less favorably. So it's a fascinating illustration of the racial divide. To the judge, Williams had not proved his case. To the defense, it was a frivolous claim. To the Williamses, the outcome was an irrational decision by a judge momentarily incensed by an outrageous verdict. We may be tempted to dismiss his case as eccentric, I sort of already said this, but it's interesting to consider the discussion of the defendant railroad's attorneys when we were discussing another case with him. He said, so after we had talked about the Williams case, I say, hey, tell us about another case. This is a good interviewing technique. Just keep them talking until they kick you out. So tell us about another case. And he told us about another case where the company had done things that they were not proud of. The company refused a settlement in that case, and they called it a ransom demand. So even when there was something out of whack, they still said, no, we're not going to offer any kind of settlement. The EEOC ruled against the defendant, and no conciliation was reached. The company won part of a summary judgment and lost part of a summary judgment. And as the trial approached, the defendant agreed to a significant settlement but the company would not settle in that case. And that's how they treat the cases. So in addition to trivializing claims, defendants, even the high executives who are supposed to be committed to human resources, can affect how employees think about going to court, like this fellow, just by what they communicate as the person makes the complaints within the organization. and you can click one more time, this was on his desk, right? So this is the vice president of human resources. And if you go into his office, it's ashes of problem employees, right? Like they're dead and they're cremated and those are their ashes. So the message from business is not that we are amenable to creating racial equality, I think is the point. Okay, you can click last one. So in the two cases that we talked about here today, Annie Daly and Franklin Williams, we find that consistent with Buehmiller, litigation places a heavy burden on plaintiffs. Just as these two individuals were disadvantaged in the workplace, they were also disadvantaged in court. The burden on plaintiffs is particularly intense in individual cases when they're going it alone. Our quantitative analysis of outcomes show that cases, even just with two plaintiffs, enjoy much more success. Our theory is that it makes it much harder to claim that you're just a crazy person if there's another plaintiff. A solo plaintiff can be said to be misperceiving the situation, but two plaintiffs, much better results. And yet, as socio-legal scholars, and as Annie Daly said, we shouldn't lose sight of the fact that at least these plaintiffs had their day in court, right? Even though they both lost, they were able to make their claim against the employing organization in a court of law to a judge or a jury. The employer could not just ignore them, right? Even though they lost at trial, the employer had to put up a defense. And all of our plaintiffs talked about the symbolic importance of making the company go through that. So despite the outcomes of the cases, the parties didn't change their interpretation of the validity of the construction of these cases, right? Annie didn't say, well, the jury said I wasn't discriminated against, so I guess I wasn't discriminated against. She still believes she was discriminated against. And the same with Franklin Williams. Defendants, in contrast, reject the assertion that race played any part in the termination of these plaintiffs and blame plaintiffs for reading race into the situation or playing the race card, which is bad. Both the survey data on frivolous cases and perceptions of defense counsel in a case with stronger facts than these cases indicate that this is a general pattern among defendants. And that's really what we're arguing, that the place in which these actors are situated have such a strong impact on their opinions that the litigation process is, of course, adversarial, but unlikely in the end to create a solution that both parties can feel happy about. This tendency by defendants and their counsel suggests that what matters most to defendants in handling cases and in design of their personnel practices is legal risk and not the moral force of anti-discrimination or the legal force of anti-discrimination. There's no easy empirical resolution over the debate of frivolous cases. We looked at thousands of cases and we tried to code them. Do we think this is a good discrimination case? And we couldn't get any intercoder reliability. And we'll talk more about this in the seminars, but you can do this better in medical malpractice cases where there are laws and regulations about how you have to keep a medical file, so then you can hand it over to another doctor, and that other doctor can say if the first doctor behaved reasonably. But in litigation, the file is constructed as part of this adversarial process, and so it's very hard to tell which cases are worth anything. The defendants in these two cases regarded them as weak, although at one point Ms. Daly was offered $100,000. And the plaintiffs in these two cases, in the eyes of the law, did not carry the burden of proof. But that doesn't mean their cases were frivolous either, in what they meant to the plaintiffs, or in terms of the evidence the plaintiff presented, or in terms of the plaintiff's relationship with the state, that there is a state mechanism for trying to deal with discrimination, even if it's flawed. As we argue in our Journal of Empirical Legal Studies article on case outcomes, the system of employment civil rights litigation is dominated by individual claims, and the legal system largely functions to deflect those claims, dismissing or settling. Nonetheless, we see in the cases of Annie and Franklin that the law at least provided forum for presentation of claims. In these cases, and in the majority of cases, plaintiffs lose when there's an authoritative final ruling. Yet the pattern doesn't mean we should accept the construction that defendants place on these cases as unworthy of serious investigation and adjudication. Nor should we think that without at least the threat of litigation, that rights will have as much force in the workplace as they might without the opportunity to sue. So I'm happy to take your questions about the efficacy of this litigation system. Yeah, you should definitely clap.